It's important to properly dispose of unwanted medication or sharps. MedProject offers free and convenient disposal options near you. To learn more, call 844-MedProject or visit medproject.org.
Sometimes the transition to fall and winter feels like experiencing every season on the same day. The shoes in the Allbirds Mizzle collection were made for misty morning walks, surprise snow days, and anything a trip to the dog park might bring. The whole collection brings together water-repellent technology and classic style, so you can stay warm, dry, and comfy during your everyday adventures. Check off your errands with the Wool Runner Mizzle. Dash through cold and wet weather with the Wool Dasher Mizzle. Or upgrade to next-level protection with the Wool Runner-Up Mizzle Plus. Go to allbirds.com and use code FRESHSOCKS for a free pair of socks with your purchase. ALLBIRDS.com, code FRESHSOCKS.
Welcome to Pretty Lies and Alibis. Join us as we seek the truth and travel the long road to justice.
Hey, everybody. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi Fruit Loop. What you know?
Did you know that a woman who lost her wedding ring found it 16 years later on a carrot in her garden? It grew through the carrot.
You know, I've seen a picture of that.
Yep. She lost it like she was cooking for Christmas, and she looked everywhere for it, couldn't find it. Didn't think she'd see it again.
That would be crazy. Like all those years. What? So I guess when the carrot grew and she pulled it, there's a ring. Look, I have my own little crazy fact. All right. So, I told you guys I'm doing this weird history thing.
Yeah.
And so it was talking about the phrase, I'm going to light a fire under somebody. Okay. So this originated with child chimney sweepers back in the Victorian era. So they would use kids because the flues were like 18 inches wide. And so they could fit kids down in there. And it was pitch dark. And they would have to like crawl and put their body in all these different shapes and, like really contorted. They had growing problems because of it. But anyways, when the kid would like take too long, they would literally light a fire in the fireplace. And that's how the phrase light a fire under somebody got started.
Yeah, it's like Mary Poppins. That's what happened.
Yeah, but I'm going to tell you, after watching that, chimney sweeping was nothing like Mary Poppins. Nobody was dancing.
Yeah.
Those poor kids, sometimes they get lost in there and then they would die. And then the only way to get them would be to break the wall down. It's very sad stuff.
Yeah, it's like here in our mills way back when, our textile mills and all. Yeah. They would climb through the floor to clean out the cotton and stuff out of the floor. And they would get stuck in those things.
It's crazy. History's wild. I'm telling you, I dig this channel right now. And I'm going to tell you, I learned all about Teddy Roosevelt. He was a baddie. He was like a dude's dude. I'll have to post the link. Very cool stuff. All right. So we want to give a shout out to our sponsor, Too Cool T-Shirt Quilts. You can go to toocooltshirtquilts.com/Pretty Lies and Alibis and get you a quilt or a pillow or something. My kids have been having a lot of friends over lately and they love the Clemson quilt. So, all right. So can we just say that there's been a lot of activity on the portal? I mean, not literally, but the court portal for Lori lately. And I know people are a little bit back and forth. Is she competent? Is she not competent? We don't know for sure. It's just guessing. I still say she's competent because, well, first of all, on May 28th, 2021, which was 298 days ago, the stay was entered into the court system. So she had a scheduling conference yesterday at 1:00. Nothing was announced. We didn't know about it till after it had happened and they had put it up. So I went back and looked. And as far as I can tell, this is the first scheduling conference I've seen since her being deemed competent.
I think the big tell here is they're not saying anything.
Right.
So up until now, when she hasn't been competent, they've said she's not competent. She's going back for X amount of days.
Yeah. So I think for me too, just all of these different filings or these, different orders that have been posted. So June 9th, 2021 was the last time she was to have a scheduling conference and that one was vacated. So there were two different orders entered in just today. One of those was an order to close the hearing and seal the record. And we aren't sure if that hearing is for the scheduling conference yesterday or a new one. Nothing has been posted as of right before we went on that there was another hearing today. So who knows? Lots of activity. I will say that. Don't forget tomorrow, the motion to dismiss is on for 11:30 Eastern. That's for Chad. The motion to dismiss, it's still going to happen and it should be streamed. I will not be home when that's going on, but I'm going to keep up with it when I'm out. So the big thing was the motion to sever was denied. And we're going to break down that document, the decision for Judge Boyce.
Dun, dun, dun.
I know, right?
Yeah.
So the court is aware Chad and Lori are married, and Lori was indicted in Charles's murder case in Arizona. Chad argued a joint trial would be prejudicial, saying the difficulty in preparing the defense and doing the necessary preparation when there is uncertainty as to whether one of the co-defendants will be present for the trial creates a number of challenges. Get that. That's valid.
Yep.
Chad contends that the evidence of other wrongs or acts by co-defendant Lori will have a negative impact on jurors should these two remain joined. So the court has considered 3 potential sources of prejudice when considering a motion to sever. Number 1, the jury may confuse the evidence and convict the defendant on one or both crimes when it would not convict him of either if it could keep the evidence properly segregated. Number 2, the defendant may be confounded in presenting defenses where he desires to assert his privilege against self-incrimination with respect to one crime, but not the other. And number 3, the jury may conclude that the defendant is guilty of one crime and then find him guilty of the other because of his criminal disposition.
So the defendant has the burden of showing such prejudice. In addition, the defendant is facing charges of conspiracy. The court is persuaded with the state's argument supported by federal case law that conspiracy charges weigh in favor of the state's objection to severance. So the court concludes that the defendant has failed to meet his burden in establishing a joint trial would be prejudicial, thus necessitating severance. So Chad's main argument is that Lori's status causes uncertainty. The court does not dispute there may be an additional burden on the defense due to the inability to know if Lori will be fit for trial when the trial begins. That uncertainty in preparing for trial is not a determining factor for the court to review Idaho Criminal Rule 14 or the cases interpreting it. So, I mean, we just talked about it. Mm-hmm. We think she's coming back.
I really do. I mean, and then somebody today pointed out some of the language in this and said this is proof she's not. But if it hasn't been completely ordered, for instance, if Archibald has objected and he can object to her being found competent from what I've read, you've got to have a hearing on that. Nothing is official until all those babies are put to bed and then she's transported back. I haven't lost hope. I won't be surprised if she's not, but yeah. I just feel like she is. Okay, sorry.
Yeah. Prejudicial joinder results from 1, the jury's confusion of evidence, 2, defendant's inability to meaningfully present defenses, and 3, a jury basing guilty determination on criminal disposition. So the defendant has not alleged or shown that any of these forms of prejudice have resulted or will result based on the stay in Lori's case. It's time to feature our paid sponsor for this week, June's Journey. June's Journey is awesome. I'm absolutely obsessed with this game. If you love a good whodunit, June's Journey is the game for you. It takes you back to the roaring 20s as you play as June Parker, who is an amateur detective. She takes you along as you experience tons of twists and turns as you solve case after case. Each week, new cases are available. While solving the case, you get to look for hidden clues to solve the mystery. To be honest, June's Journey helps me wind down and relax right before I go to sleep. I truly look forward to playing this game in my free time. Another awesome thing about June's Journey is it is free to download. There is a detective in all of us. Find your inner detective. Download June's Journey free today on the Apple App Store or Google Play.
It's important to properly dispose of unwanted medication or sharps. MedProject offers free and convenient disposal options near you. To learn more, call 844-MED-PROJECT or visit medproject.org.
My brother-in-law died suddenly, and now my sister and her kids have to sell their home. That's why I told my husband we could not put off getting life insurance any longer. An agent offered us a 10-year, $500,000 policy for nearly $50 a month. Then we called SelectQuote. SelectQuote found us identical coverage for only $19 a month, a savings of $369 a year.
Whether you need a $500,000 policy or a $5 million policy, SelectQuote could save you more than 50% on term life insurance.
For your free quote, go to SelectQuote.com. SelectQuote.com. That's SelectQuote.com.
SelectQuote. We shop, you save. Full details on example policies at SelectQuote.com/commercials.
The trial is not set until January of 2023, which that's a long ways away.
It is.
And that gives the defense adequate time to prepare for a trial with or without Lori. The court agrees with the state's assertion that careful jury instructions in this case can neutralize the effect of any prejudicial evidence. And the court concludes the concern of Lori's charges in another jurisdiction creating prejudice at trial can be cured through motions in limine and
remember we did this. We butchered it. I think it's in limine.
In limine.
Isn't that right?
I don't remember. I just know the pro vice. I got that
Pro
one.
vice.
Yeah, I got that one. An appropriate jury instructions. For example, if you're involved in a DUI accident and discover that there's a witness who is inflating the details of the case, then your attorney may create a motion that requests that the witness's testimony be thrown out before the case proceeds.
Yeah. So what they're saying there is, if a witness were to get up and say that this defendant said that, then, you see it all the time. I mean, judges instruct the jurors, like, you can't consider this when you're considering guilt.
Yeah.
So the defense also requests the state be ordered to present to this court in-camera statements and or other evidence the state intends to offer from either defendant. So in camera means in private. And the court notes that Idaho Criminal Rule 14 provides the court with discretion to order any statements and confessions the court deems relevant to the issue of determining relief from prejudicial joinder. However, the rule is not so broad as to permit the order of any other evidence that may or may not be introduced at trial. The court concludes that ordering the state to deliver in-camera evidence is not warranted. Both parties agree the discovery has been extensive in this case and that discovery is complete or nearly complete. Despite the extensive discovery that has taken place, the defendant has not identified what statement, if any, should be ordered for in-camera review by this court. The rule says the state may be ordered to provide the information, but is still on the defendant to show the prejudice in joinder. By merely requesting the court to make its own broad review of the evidence without making any example as to what specific statements or confessions are prejudicial, the defendant has not met the burden here to demonstrate a need for any such review. During the hearing on this matter, the court specifically inquired The court specifically inquired of the state to whether any concerning statements or confessions existed that would necessitate. See, look, y'all, I'm having to drink coffee through a straw. If you didn't see Crushes live, I was eating some corn nuts.
Yeah, I saw it.
Oh my gosh. And one was like rock solid and took part of my molar with it. Oh my gosh.
Dude, you still eat corn nuts?
Dude, remember we used to eat those all the time on road trips?
Yeah.
Yeah.
I haven't had them things in forever.
Oh, I'm not eating them again because I just can't afford the dental work. So during the hearing on this matter, the court specifically inquired of the state whether any concerning statements or confessions existed that would necessitate the court's review, including whether a Bruton issue exists. The state said neither statement or confession exists. An in-camera review is not necessary and will not be required. Defendant's request for such an order is denied. The defense didn't meet their burden to persuade the court that a jury is likely to confuse evidence in the case, that the defense will be unable to meaningfully present defenses, or that a jury is likely to base a guilty determination in this case due to evidence of criminal disposition. The court must conclude that the cases will not be severed.
Dun, dun, dun. So further, the court concludes that a joint trial will serve in the interest of justice by providing judicial economy and efficiency, avoiding possible inconsistent verdicts. Accordingly, the defendant's motion for severance on this basis is denied. This is going to save so much money.
Oh, yeah.
Finally, the decision to deny the motion to sever in this case shall in no way be construed as a stay on this case, pending the competency determination of co-defendant Lori Vallow. Severance is a legal issue relating independently to each defendant in their conspiracy case. However, availability for trial is not determined under the same legal analysis. And while it is true the defendant waived his right to a speedy trial, that waiver is not indefinite in time and scope. Notwithstanding his waiver and the current inability of the co-defendant to be brought to trial, due process still requires a defendant be afforded a jury trial without unnecessary or excessive delay. And the court's December 3rd, 2021 scheduling order requiring trial to commence January 2023 remains in full force and effect.
Boom. Okay, so Kay spoke to Nate over at East Idaho News when they found out that this was not going to be severed. And she said they're relieved. She said having the cases joined will save us from more emotional torture. We've already been through enough anguish from this evil duo. They'll be staring at each other in court, feeling miserable they can't touch.
I love it.
I love it too.
Okay.
Yeah, I mean, look, this is a huge case. To sever them, it would be a disaster on a million fronts. It would be I mean, first and foremost, for the family to have to sit through it twice.
Yeah.
And we've talked about all the reasons. So one thing that we do have is the patient handbook from the hospital where she is. And I'm not putting it out there because, but I got a copy of it. So I think what we're going to try to do either tomorrow or Thursday is kind of just go through and it tells what they're able to do, what they're not able to do, what they have at their disposal. It's interesting, nothing earth shattering. I don't think it's like jail. I think it's a little bit nicer than jail.
Yeah.
But we shall see. And of course, we'll keep an eye on the portal, everything else to see if there's any clues of movement with her. Who knows? It's up in the air still, but we'll stay on top of it.
And I think we did talk about, I don't even know what episode it was. I have to go back and look. But we did talk a little bit about that, about things in most facilities of what goes on and whatever. But it'll be
but I have the one from where she is.
Yeah,
like I've seen pictures inside and everything. It's, it looks like a hospital essentially. But anyways, hopefully she's having to pack her belongings to go back to jail to face these charges. It's time,
Yeah,
I've
been in our mental facility here, and it is not fun.
I've never been there, but I have heard stories, and it's unfortunate that people, do actually struggle with this stuff. It is, I can't imagine not being in control of my thoughts and stuff like that. But my heart goes out to people who are suffering because it's everywhere.
Yep.
So, all right, guys, that's all for tonight. We will talk to you tomorrow. We just wanted to throw this out and go through all this.
Okay, round two. Name something that's not boring.
A laundry? Ooh, a book club. Computer solitaire, huh?
Ah, sorry, we were looking for Chumba Casino. That's right, ChumbaCasino.com has over 100 casino-style games. Join today and play for free for your chance to redeem some serious prizes. ChumbaCasino.com. No purchase necessary. Void where prohibited by law. 18+ terms and conditions apply. See website for details.
With Lucky Land Slots, you can get lucky just about anywhere.
Dearly beloved, we are gathered here today to... Has anyone seen the bride and groom?
Sorry, we're here. We were getting lucky in the limo and we lost track of time.
No, Lucky Land Casino, with cash prizes that add up quicker than a guest registry.
In that case, I pronounce you lucky.
Play for free at LuckyLandSlots.com. Daily bonuses are waiting. No purchase necessary. Void where prohibited by law. 18+. Terms and conditions apply. See website for details.